All right, so we're live. We'll just give a few minutes for people to come in, and then we'll take it from there. All right, so we're live. All right. Good afternoon, good morning, good evening, everybody, wherever you are. You're welcome to this webinar today, hosted by the Institute of Chartered Mediators and Conciliators, Lagos branch. We are glad to have you with us. I hope we'll have quite an interactive session today. Just before we start, I want to take some time to introduce the panelists, and I will be starting with the ladies first. So we have Mrs. Achere Cole with us. She's Deputy Director with the Lagos Multi-Door Courthouse. She's a senior accredited mediator and a fellow of the Chartered Institute of Arbitrators. She's well versed in institutional arbitration and mediation, and she will bring a lot of experience here with us today. Mrs. Cole, you're welcome. We have Ms. Yejide Oshukeye also here with us today. She's an arbitrator and mediator, a fellow of the CIAB, and also a senior accredited mediator. She has a lot of practice in ADR and litigation, and I'm sure that she'll be adding a lot of value to us. She's also the court representative of Nigeria ICC Commission on the ICC Court of Arbitration in Paris. Ms. Yejide, you're welcome today. We also have with us Mr. Samir Sher is the principal partner of Sher Associates in India, is director of CIAB India, is an arbitrator and mediator, and a very, very accomplished mediation tutor, and is a very strong promoter of ADR in India and the Far East region. Samir, good friend of mine, good to have you with us here today. And I'm Dr. Adeyemi Agbelusi. I'm a fellow of the ICMC, a fellow of the CIAB, mediator and arbitrator, and I'm the chairman of the Lagos chapter of the ICMC, and I'm happy to be the moderator and the host this evening. So, without much ado, we're going to go to the topic today. We're looking at ethics in mediation. And just to give a background, mediation is a very flexible ADR process, and it allows for creativity and ingenuity between the parties, the counsel, and the practitioners. And this flexibility means that each mediation develops its own unique approach, and therein lies possibly a need for ethical considerations. So, while mediation does not have any global or universal body of rules, it definitely does have a clear direction in terms of ethics, and it's not a wild field in which anything goes. So we're going to look at different aspects of ethical considerations in the field of mediation, and we'll see how we can help potential clients, help practitioners, and also help mediators understand their ethical responsibilities and know that the practice of mediation protects everybody's interest. So without much ado, I'll just jump to Mrs. Achere Cole to start off this evening by just telling us who exactly is a mediator and how is the practice of mediation regulated. Ms. Cole, you're muted.
Hello, Dr. Bilisi, can you hear me now?
Yes, we can.
Thank you very much. And I said good evening to everyone. A mediator is a person who you would say helps somebody settle a dispute. But that's the common parlance, and in very simplistic terms, what people understand to be a mediator. But if we're looking at mediation or the mediator as a professional, then the mediator is a person who actively assists parties in reaching a confidential negotiated agreement. You know, is a neutral third party who actively assists parties in reaching a confidential negotiated agreement. So you would see I've added on one or two things. One is that he's a neutral person. He actively does this, and then he also makes sure that the process is confidential. He's also someone who ensures that he involves the parties in the resolution, you know, of the dispute. So that's who a mediator is, taking into consideration all the factors that are crucial for a mediation process. And for the second question, Dr. Bilisi, you said, Dr. Bilisi, the second question.
Okay, I said, how is the practice of mediation regulated?
Okay, in terms of regulation, that would depend on the jurisdiction. In some jurisdictions, they have laws which govern mediation practice. So they have a law, but in Nigeria, for instance, we can't say we have a federal law. What we have is the Arbitration and Conciliation Act, and of which currently is being reviewed, and I think it's at the National Assembly. So in Nigeria, we don't have that federal law. But at the institutional level, you can say there's regulation of mediation because each institution then has its own body of laws which govern mediation in that institution. And then the court system now, with respect to the civil procedure rules, has rules that guide the conduct of mediation. So that shows that in Nigeria, using Nigeria as a reference point, even if you do not have a federal law, you can have institutional provisions, you can have the court set out laws and rules. And then, for instance, let me use one institution, which is where I work, the Lagos Multi-Door Courthouse has a law and has a practice direction. So pretty much the totality of these things is what regulates the practice of mediation in Nigeria. But like I said, in other jurisdictions, and I'm sure Samir can help us, they actually have a mediation law which regulates the practice of mediation.
Yes, Samir?
Yeah, no, I agree what Cole said. In fact, so far as India is concerned, till date we don't have a law as such, but recently a law has been drafted and it is going to be promulgated maybe in this year. So we'll see a mediation law being coming into India, which will govern and regulate the whole mediation practice, both from the mediator's perspective as well as the practitioner's perspective. But how far it's going to be helpful, we are yet to see because it's not yet come out. So we'll have to wait how beneficial it could be as a legislation.
Okay, I'll come back and ask what are your thoughts on regulation of mediation. But let me go to Ms. Shukaya now. Actually, in your own mind, what is the obligation of a mediator to the process of mediation?
Well, you can look at this in two scenarios. What to expect from the mediator, and then what to expect from the parties or their counsel. Now, we call this the cornerstone of mediation, and there are so many of them. For a mediation process to be successful, there are some cornerstones that the mediator himself or herself has to abide by, and also the parties and their counsel as well. Now, some of the cornerstones are confidentiality, which is very, very, very huge. A mediator must be able to keep in confidence whatever is told to him or her during the process. Aside from the parties already entering into an agreement to mediate, which also has confidentiality clauses, not to disclose whatever is discussed in the mediation process, the mediator herself or himself has to hold whatever is said, whether in private caucus or during the entire mediation process, confidential, and same with the parties as well. There's also self-determination, which is one of the cornerstones of mediation as well. There's equal treatment. A mediator must always treat the parties equally. You cannot tilt to one side or favor one side, which is why impartiality is very important, to ensure that you are not familiar with any of the parties, so that you don't tend to be biased towards any party or to be impartial to any party. There's independence, there's a due process, there's a full disclosure, there's also competition. That's on the side of the mediator. Now, on the part of the party and the counsels, the mediator has an obligation to ensure that the parties come to the mediation process in good faith and not to waste the time of anyone. Because some people who feel they have a bad case may decide to come to the mediation just to waste time, just to buy time. So it is the duty of the mediator to ensure that any party that comes to mediation comes in good faith. And there are ways that the mediator can actually find out and ensure that this is put in place. Now, the mediator should also ensure that you take the parties through the best alternative, the WATNA and the BATNA, so that parties know exactly what the worst case scenario or the best case scenario will be in case the matter is not settled. A mediator should also ensure that there is an intention to settle. There's an intention to discuss. There's an intention to negotiate. Because yes, the negotiations at the end of the day may not go well, but once that intention is there, then it's more likely that the parties will achieve the reason why they have come to mediation. Now, the mediator should also ensure that the parties have the intention to abide by the rules of the process. There has to be order in the process. So the mediator is like the director, is like the instructor. You know, you're not a judge, but you have to take charge of the process to ensure that the parties work with you for you to achieve the objective of mediation. The mediator should also recognize that it is party-driven, not driven by the mediator. The parties themselves and their counsel are the ones that will drive, you know, the negotiation process to reach a negotiated settlement. So parties must be involved in the entire process all the way. Now, the mediator should also play the role of an advocate and not an advisor. You don't advise them on what to do. You only ensure that you play a role that assists them, you know, to open up, to discuss, to negotiate, not to advise them on what to do. We've talked about confidentiality and impartiality. The parties themselves and the counsel have to ensure that the mediation process is kept in confidence. And there's also the issue of, when they come to the arbitration, the mediation process, to ensure that there's nobody around, to ensure that the entire process is kept confidential. And then to also ensure that the terms of settlement are workable. It's not enough to just suggest things, parties and they can't suggest things, but to also ensure that whatever is suggested to go into the terms of settlement, it's also workable. I think I'll stop there for now. Thank you.
Thank you very much. The Q&A open. Our audience can type any questions or contributions they have to the Q&A, and we'll treat them when we come to that point. Thank you very much, Ejide. The mediator obviously has quite enormous obligations to the mediation process, and it appears that they are the driver of the process, even though the parties will maintain their self-determination. So I'll go back to Mrs. Cole. Mrs. Cole, in your own thoughts, in the crucial role that the mediator plays, what should be a body of ethics for mediation?
Okay, so I probably might be a bit repetitive because Mr. Srinkaya has addressed quite a number of the principles, that are written into the body of ethics or the code of ethics, that typically institutions have. The American Arbitration Association, International Mediation Institute, Lagos Multi-Door Courthouse, all have codes of ethics which the mediators who work with those institutions abide by. And these codes are hinged on the principles of mediation, and which tells you how sacrosanct these principles are. Now, these principles essentially, again, of course, are one, confidentiality. In fact, confidentiality cannot be overemphasized as a code of ethics, because many parties that we see, and this is what we see in practice, and which is what it is in mediation, want a confidential process whereby they can air their minds freely, either in the joint meeting or in private meetings with the mediator. Another code would be self-determination. So for instance, today, I got a call where there was a deadlock in the mediation, and the mediator said, I am going to tell, it was a family mediation, I am going to tell the respondent, who is the man in the family mediation, that he should just accept not to, he should accept the terms of the woman. And the terms really were that I have 3 boys for you and I want to have full custody. He should accept the terms, and that because they were boys, they would look for him later on. Now I'm discussing self-determination. Now you see, there's that's why the codes exist. The challenge for that mediator, immediately I say you're crossing the line. So you're going to go into that room and act like a judge and tell the respondent that, look, this is what you should do. And that's the essence of the code of self-determination. It is the parties who must make the decisions. And in making those decisions for themselves, the way the mediator does it is to really find out what their interests are, back to basics. What is his interest? Why is he asking for this? So that's what, and that's why you have self-determination as one of the codes. Another one, which is, I would say, quite, it's peculiar. It's peculiar because it might be difficult to track, and that is solicitation or gratification. It's a major code for mediators. And the first time that it had always been in the code, I remember I was teaching once and a senior advocate said, what's the guarantee that when you go into that room with one party, you're not going to switch and think of things from his own perspective? And it got me thinking that, will the mediator really switch? What could make a mediator switch? Can gratification make a mediator switch? Can you even switch your thinking? Because it's mediation, you're not the judge. And we had an instance, and I'm talking based on institutional practice, we had an instance where a mediator in the Lagos Multi-Door Courthouse was observed receiving an envelope. And we discussed these things openly because it's a code. It is a code. And the envelope was put under the mediator's file. And immediately the case manager saw the envelope put under the mediator's file. The case manager alerted, her supervisor. It was dealt with. The mediator said immediately it never happened because she wasn't caught. She wasn't caught red-handed, so to speak. The case manager just observed it. But what did we do? We had to take her off the panel, because in setting codes, there must always be a method of enforcement. So that's discussing gratification. Then to what extent do you say do not receive gratification? It's been a major point of discussion. So if you have a case and the case is the land dispute. And the people are so happy. It's even happened to me. The people are so happy and they say, mine wasn't land, mine was money. And they say, look, you've done so well, let me give you money. Or I'm using a very, Samir, I wonder what you have in your country, some real good real estate area. In Nigeria, for instance, well, in Lagos, a really good real estate area would be Banana Island, I think. So if the party says, you've done so well, let me give you a land in Banana Island, would you accept it? Now the courts say no. And the questions that I always ask are, this is always a very topical issue. The mediators during training then ask you, when can I accept it? I've done so well. So can I accept it in 3 years? Can I accept it in 5 years? Can I accept it in 10 years? What is the limit of not receiving gratification from anyone? And what we've said, we've always said, just don't find yourself in a position whereby you have been offered anything and you accept it. In fact, to a great extent, what kind of relationships are you going to have with that person going forward? Do you know why? That question the SAN asked, it now comes into play, because even if one side who maybe wasn't balanced in terms of in terms of party control, then says, oh, I agreed because the mediator made me agree. And then you took money from the person that made that person agree. That lets you understand the reason for the code. That lets you understand why that code exists, why you can't accept anything. But it's a very difficult code for people to abide by. But it is there. It is one of our codes. So I've discussed competence. We can't discuss everything. Competence, confidentiality, self-determination, gratification. These are major issues that we deal with. And then neutrality. This neutrality, for me, and I think even as a code, but the way I see it, is overt. So which means you can see it. It's obvious the person is not neutral. But what about the neutrality that is deep-seated within you? Are you neutral within? And that's the teaching, and that is the code. Where you find that you're crossing the line, and I'll give you an instance. I recall, and in one of our mediators has said to us in the training that, look, don't ever assign cases that are matrimonial matters to me, obviously, because of the person's background. And she went on to explain. So she could say that openly, that I wouldn't be neutral. So it is a code. It's a code that says you shouldn't only be neutral, seem to be neutral, but be inherently neutral, which is internal. Now, so that's for neutrality. Another one is competence, and I think I'll just stop here, and there's so many more. Competence. What kind of matters do you really handle? In Nigeria, for instance, we cut across so many areas of practice. We do commercial, we do aviation, we do oil and gas. Whatever the court sends to you, we handle them. But if you find out that you do not have the competence, because there are some cases that are so technical that even if you have the general teaching for mediation, but those cases that are technical, you should say that, look, you can call in a mediator who has the technical expertise, or call in an expert with the technical expertise, but you need to own up to it. Or even if you don't own up to it, just get a necessary resource. So these are just a few of the ethical codes that institutions abide by. There's so many more, and they're intentional. Everything is hinged on the principles of mediation and hinged on protecting the profession of mediation generally. So thank you, Dr. Bilisi. I hope that.
Thank you very much.
May I just add one or two
Yes,
thoughts here?
I was coming to you. Yes.
Well, I think
Please give us your experience from the international perspective. Yes.
I think both Yejende and Aishwarya has collectively, discussed all the major, ethical issues so far as mediators, as a person as a mediator is concerned. There are one or two which I would like to add a little more detail is conflict of interest. This is a very important aspect from the mediator's perspective. that, and I think Yejid did mention about disclosure in brief, which, and this relates to that only, that a mediator should immediately disclose, and if he or she knows that there is some conflict of interest, then he or she should not take up that assignment as a mediator, as an appointment as a mediator. That this is very, very important, because it ultimately relates to neutrality, it ultimately relates to impartiality. Because you see, when we are talking of mediation, we must appreciate that we are talking about emotions, we are talking of psychological aspect more rather than the law and the facts as such. So when we are talking of emotions, when we are talking of basically the mind game, the psychological aspect, the human aspect, the basic human mentality come into picture, and it's really very, very difficult for a person in such circumstances to remain neutral, to remain impartial. It's a basic human tendency, and therefore, according to me, the job of a mediator is much, much, much more difficult than an arbitrator, because arbitrator has to simply go by the law and decide the case, and matter gets over. But here, you see, the mediator's job is so difficult. He or she is not supposed to decide anything. He or she is not supposed to even advise anything, but at the same time guide the parties to a resolution. Now, how you going to do that? Being impartial, being neutral, it's really very difficult. But that is the code. That is what we are talking about. That within this four corners of ethics, you have to guide the parties to come to a win-win situation. And just last one thing is honesty. I think the mediator has to be totally honest, not to himself or herself, but to the parties as well. For example, if suppose during the caucus, if a party has disclosed something to the mediator, and then when the other party in the caucus asks the mediator whether the first party did tell you something about this, some issue, then the mediator should not, of course, disclose what the other party has said, but he or she should admit that yes, I have been told something on this by the other party, but I am not going to disclose it because of the code. So this honesty will definitely be appreciated by the parties. So I think that is another trait or another ethical practice for the mediator is concerned. Thank you.
Thank you very much, Samir. Obviously, that is why there's very strong emphasis on mediator training, because apart from the body of ethics, there's also a very strong need for self-awareness, emotional intelligence, and really self-governance to adhere to this code. Thank you for your submissions. Now, back to you, Ejide. Can you share with us some challenging scenarios that you have experienced personally or you have heard of that could face a mediator, and how do you think we can do?
Okay, I can think of one or two, actually about three, quite a number of them actually, different challenging situations that I found myself. And I'm happy I had the wisdom to tackle them properly. First is when parties or counsel become over familiar or too friendly or try to bribe an arbitrator, just like Ms. Cole has said. There was an instance once when I went into the multi-door court for a matter, and I met an old classmate. He recognized me, I didn't recognize him, and I didn't even know he was a lawyer. And he said to me that he had come for a case. And I was rushing into the lounge to prepare myself for the case. So we exchanged cards, and I thought that was it, only for me to go into the, to start the session. And there he was, because I had gone through all my documents and I didn't recognize any of the parties or their counsel. So there he was as a counsel to a party. It was a huge case. And immediately as I gave my opening statement, I disclosed there and then that I've known this person, although we haven't seen in about 30 years. I met him this morning and we went to school together and all that. And even before I finished, the parties were like, oh, they don't mind, they've heard about my reputation, this and that and everything. I said, well, I still have a duty to disclose. Now, lo and behold, the parties agreed that we go on. Lo and behold, the following week, this counsel shows up in my office, being very friendly and all that, and went into talk about, oh, he didn't know I was into mediation, and he drops the bombshell. His client was in the car and wanted to see me. And of course I went ballistic and I said to him, it is not, that's not done, it's not allowed. I'm sorry, you cannot come here anymore and your client is absolutely not allowed to see the mediator. And he said, but how would anybody know? I said, look, you're a lawyer. I'm sorry, I'm not a mediator, but there are some principles that are not allowed. How would you feel if the other party was trying to see me in private? And obviously from the look of the matter, it was obvious that he was the one that, had some settling to do. So I walked him out of my office. And of course, the session didn't go well because they were now being difficult and all that. So I stylishly had to recluse myself from the matter. I invited an intervener to come and take over the matter, and it was the intervener that actually concluded the matter. So in instances where you are in a situation where a party is trying to bribe you or a party is trying to to show you appreciation, it's better you either recluse yourself or you find somebody else to take the matter. Another instance, which is very similar to what Mrs. Cole mentioned, I had concluded the land matter. It was a huge land matter. The traditional rulers were always there. There were so many of them and all that. And I concluded the matter, they settled, they were all very happy. And about 4 months down the line, I got a call from my landlord. He was a landlord in my office. And he said to me that there are so many animals in the animal farm that are running around his compound that some traditional ruler apparently sent somebody to give me a gift. For the life of me, this matter had closed and settled months before. I wasn't even in town, and I had to apologize profusely to my landlord that I knew nothing about it. It took me a while before I actually eventually found out who he was and who it was that sent the gifts, some chickens and goats and yams and all that, So obviously I had to tell the landlord to dispose of them. But what really shocked me, because I thought it was a one-off thing, was that it happened for 3 years consecutively. So I was actually on the mailing list of the KBAC, that's what we call traditional rulers. So I had to get in touch with the case manager to put a stop to it. So I was in shock when it happened the 3rd year running. So I had to make a conscious effort to stop that kind of thing. Now, one particular challenging scenario that I found was where parties in caucus, because mediation is supposed to be a confidential process, where parties in caucus disclose very serious issues to you that you just can't sweep under the carpet. Of course, you can't reveal it to the other party because you're under a confidential state. But when parties disclose matters of life and death or matters of child molestation, somebody admits to you that he's been molesting his child, he's sick, things like that are very, very serious and very, very disturbing. Now, do you disclose that? Do you break that confidentiality oath or do you just keep quiet? So for me, what I did, well, of course, I didn't disclose to the other party. I had to disclose to the institution, and whatever the institution did with the information was their own, So sometimes you're actually faced with very, very serious scenarios, and it's actually quite confusing. Somebody is suicidal, says, I'm going to commit suicide if this doesn't happen, and what do you do? So those are some of the challenging situations that I have faced as a mediator. And, sometimes it takes a lot of advice, a lot of thinking, on what to actually do in such situations. Thank you.
Thank you very much, Ejide. Thank you for sharing all those scary animal details that we got. Anyway, I'll go back to Madam Cole. Madam Cole, obviously following up from what Ejide said, mediators face different challenges because of their close proximity to parties and counsel. The judge, the arbitrator may be insulated by the registrar or the tribunal secretary, and parties know they shouldn't normally go to these individuals for any contact while the matter is going on. But in mediation, there's a lot of emotional attachment and communication and a lot of discussion and openness, and this could lead to family or people crossing the line. Can you share from your experience, from perspective, also just like AJ experiences?
Thank you, Dr. Wilisi. So, Mrs. Oshunkaye, your examples were quite interesting. But they're so real. I think I just share about two, and I'll use it from an institutional perspective, what we've seen. And there was one in which now in this case, there was no disclosure. The mediator had met apparently counsel during youth service. Now, youth service is a year after we, in Nigeria, you go to serve your country for 1 year after your university education. So for people who maybe have been in practice for about 30 years, 35 years, you can imagine they wouldn't recognize that person, just like Mrs. Oshunkaye didn't recognize, this particular person. But along the cycle of the mediation, along the process, she realized she knew him, but she didn't own up. And somehow it came out and the other party found out. And this is why we're discussing disclosure. Disclosure is actually an ongoing requirement. It's not only at the beginning. Yes, you could have signed the form that you didn't know of you don't know anyone, but during the mediation, immediately you find out she should have disclosed. Now, what happened was that the petition was written, and this just buttresses how important it is to disclose at every point in time. Petition was written and she was taking off the case in a manner that it shouldn't have been. So that's one experience that shows that the challenges and the conflict of interest that a mediator can face, and it's important to disclose, at every point in time. Another one was, so now that's in terms of conflict of interest and knowing someone. In another instance, another mediator, now this time around, it was the two parties. So the examples we maybe are used to are where one party is interested in giving some gratification or doing something because they're so happy with you. But it was the two parties that, in fact, two counsel that said, let's come together and give the mediator so and so sum of money. And they came together, discussed it. But somewhere along the line, one of the parties got cold feet, maybe, and decided he wouldn't give money anymore. And then ran to the multi-door courthouse and said, look, the other party is trying to bribe the mediator. Now, the important thing is, if that mediator had mentioned it, and I think this disclosure is also important, it's so important, not only institutional mediation, but this is institutional mediation I'm discussing. If that mediator had come to us immediately and said, these two parties have approached me and they want to give me money, immediately one party pulled out, it would have been clear to us that you were open, and that's what Samir had mentioned, honesty and openness and disclosure at all times. So for a while, we had to have interviews with that mediator to discuss if it really did happen. It was just a really strange situation. So yes, these situations happen. And like I said earlier, I did experience one, and the man was very offended when he offered to give me money. He brought an envelope with money in it, and after the session, put it on the table in front of me and said, you've done so well. Please, I want to appreciate you for all you've done. And of course, immediately, and he did, of course, he waited for everybody to leave the room. I mean, if it's so clean, why didn't you even wait for everybody to remain in the room? Wait for everybody to walk out of the room and then quickly say, please take this amount of money. But of course, I had to refuse and say, it's not within our code and I cannot accept, that money. So those are the experiences and the challenges that I can share now. Of course, there's so many more. Thank you, Dr. Abilisi.
Thank you very much. Indeed, there's a continuing duty to mediators to disclose any conflicts of interest and to maintain their neutrality and impartiality, however much the parties may want to appreciate them or draw close to them. Samir, I'm coming to you now. The Singapore Convention on the enforcement of settlements arising from mediation 2018 has come into force. One of the things that has been provided for grounds of refusal of enforcement is misconduct of mediators. Can you please address this? What should mediators look out for under this regime?
Thank you, Doctor. I mean, you see, Singapore Convention is definitely a very, very important convention, or I would say a rule of law which have been come out, especially for promotion of international mediation. What was happening was that in spite of the parties agreeing under the settlement agreement, it was making difficult for the parties to maybe go for enforcement, or many times it may happen that the settlement agreement was made out by force or coercion on one party, and then it was difficult to for that party to then later on fulfill that. And if that party wants to challenge in what were the remedies. So earlier it was very little difficult for the parties because each jurisdiction has different system, different laws for enforcement and challenges. Now Singapore Convention has done a way that become a universal practice, just like the New York Convention is for arbitration, to have a universally accepted procedure for enforcement and challenges to the mediated settlement agreement. Now, if you remember, Doctor, we had a discussion, I think probably last year, on this aspect of the so-called contradiction of when we are talking of mediated settlement agreement and then we are talking of enforcement. What is the need? These are two totally contradictory terms, because if we are talking of a mediated settlement agreement, when the term is settlement agreement, then there is no issue of enforcement. It is supposed to be decided, finalized, agreed upon between the parties, and the parties are supposed to act as they have decided, as they have agreed in a settlement agreement. So there cannot be a stage of enforcement as such. But real life situations are quite different. A party, in spite of the settlement agreements, they may back out, and therefore the issue of enforcement comes into play. Though it is said to be mediated settlement agreement, but there are chances that one party may back out and may not abide by that settlement agreement. Therefore we are talking of the enforcement part, and therefore also, as I just mentioning about, if the settlement agreement are decided or agreed upon by force or coercion, or by way of some direct or indirect fraud being played upon by one party, therefore we are talking of challenges, just like the arbitration award. So to that extent, we can definitely compare or say that what New York Convention is for arbitration, Singapore Convention is for mediation. Now coming to the question of the misconduct, what we just discussed about is the ethical practice in mediation. So when we are talking of misconduct, is basically amounts to the same aspect what we discussed, that mediator has to be very, very careful of all these ethical practices, the code and the rules which have been laid down. There are institutions like JAMS, like European Commission, ABA, they have laid down their own set of guidelines for mediators to have an ethical practice. Now, before we actually understand this, we must also understand what actually we mean by ethics. It's a very broad term. What do you mean by ethics? When you say ethical practice, what does it mean? To me, it means that it's a difference between what you think what you're doing is right and what actually is right. Now there is a very thin line of difference here, but it's very important. It's very crucial from a mediator's perspective, and this is what is we are talking of the misconduct. What we just heard about conflict of interest, confidentiality, neutrality. These are what is expected to be followed by the mediator throughout the proceedings, and to an extent even after that. So far as confidentiality is concerned, it goes beyond beyond the matter. I mean, beyond when the mediation is over. In spite of that, the duty of confidentiality continues with the mediator not to disclose what has happened, what was the settlement agreement. Now, how far this goes, it all depends upon mediator to mediator. It's a very subjective thing. I mean, you see, to an extent, you cannot lay down a code as such for the mediators to work around, because that will lead to the basic nuance, going against the basic nuance of mediation, which is flexibility. So to that extent, I think if we are codifying this practice, this may lead to more unethical issues, because as I said, ultimately we are all humans, and at some point of time that basic human mentality comes into play. You are influenced by the emotions, by the parties, by the facts, by circumstances, maybe because of the parties or your own circumstances for that matter. So it's really become very difficult to codify and to come to a standard that these are the standard which would construe as misconduct. Though Singapore Convention has tried to lay it down, but I think it cannot be an exhaustive. It has to evolve from time to time, as and when the things goes into it, as and when new cases comes up, new issues comes up. Now let me give you an example of MEDA. Many times, especially in our country, I have seen that a same person acts as a mediator and then the same person also acts as an arbitrator. Now, if I talk from an international perspective, I am sure you all agree that this is totally unethical, correct? But if there is another side of looking at it, you see, ultimately, when we talk of a person as a mediator or an arbitrator, what we are talking here is about the trust. It all goes, that's the main framework, the trust of the parties. The parties have trust on someone, and therefore they choose that particular person as a mediator. And to similar extent, it also goes for an arbitrator as well. So in many cases, especially in matrimonial disputes, in family disputes, it may happen that the parties repose that kind of a trust that a same person can be a mediator as well as an arbitrator. So ultimately it goes back on the parties' trust. But if you look from a technical perspective, from a codified perspective, then this becomes unethical, because there is always a chance that a person who is a mediator, who is party to open disclosures, open secrets being discussed by respective parties in mediation, can be influenced when he becomes an arbitrator. So it's a very difficult task to sort of pinpoint that whether this is ethical or not. It all ultimately, I think, we must leave it to the parties as such, rather than putting into a code and laying down the standards. Yes, standards are required. I am not saying the standards are not required. You must have some standards, otherwise it will all go into a mess up kind of a thing, or it will play a havoc in the system. But those standards should be to promote the whole practice, to promote mediation and or dispute resolution, rather than curtailing it. Now, Singapore Convention definitely has I mean has a step in that direction of laying down a particular standard and to see that there is a universal code so far as the practice is concerned. But how far it is going to be successful, we are yet to see that. Thank you.
Yes, yes, I do agree with you. In international commercial arbitration and international investment arbitration, you have loads of parties challenging decisions or award based on procedural misconduct of the arbitrators. And so I guess the fear of the international community is that should the Singapore Convention go the same way by enforcing the provisions in Article 7, subsection 2, 3, 4, about misconduct, about breach, lack of disclosure, as grounds to vacate the parties' agreement. That's a good outcome for mediation. Anyway, like you said, case law will decide as well. To you, Ejide. Thank you very much, Samir. Mediators maintain the process of mediation as the manager, as the role, the one who plays the role of driving the process of keeping things together. One of the things that very key in mediation is confidentiality. Confidentiality gives us a very safe space to speak without prejudice and explore possible solutions to resolve disputes. However, in practice, parties, counsel, and sometimes mediators don't uphold this confidentiality agreement, either in looking for advice, either in looking for options to break deadlocks or to break impasses, either in trying to basically expand the pie to see how the process can be moved forward. As a mediator, what do you think you should do if you're finding out that there are shadow parties who are giving some undue influence to what is going on in the room, haven't agreed that we will keep the process confidential?
I think it's a really difficult task of a mediator so far as maintaining confidentiality is concerned. And again, I am repeating, since we are dealing here so far as mediation is concerned on emotions, on more human connections, and therefore it is a difficult task for a mediator to to keep the confidentiality in strict sense, for that matter. Many times, as you correctly said, it may happen that to break the deadlock, the mediator may have to breach or violate this principle of confidentiality, but it is still in the hands of the mediator how far and to what extent this confidentiality is breached. As I was giving you example of the honesty, when a party is asking that did the other party disclose this to you. Now here, if the mediator feels that a disclosure at this moment may lead to a settlement, then mediator may do it, but the issue will come, the question will be asked, what about confidentiality? Yeah. So I think it is very subjective. There cannot be a universal standard to it. It all depends from case to case, from mediator to mediator, and also depends upon how and what nature of case it is. But yes, if we say that there is no confidentiality, or the mediator can be allowed to breach the confidentiality, then I think the whole system will just collapse. So if the situation comes to this level that the mediator thinks that this is the limit, I mean, there are issues of breach, then either he or she should recuse from the case, or he or she should openly disclose this fact to both the parties and let the parties decide what next to do. See, it is better to stop at that stage and let the parties decide rather than going further and then, going against your, having a blot on your own image as a mediator, and also making parties to go for challenges and unnecessary litigation later on. So it's better to just stop there, be open with the parties that this is what has happened, and now it's your decision what to do next. That, I think, is the best solution to this, and let parties decide upon it.
Thank you, Samir. Usually, let me get in touch with you.
Yes, I agree with Samir entirely. Confidentiality is agreed prior to mediation. I remember when I started to mediate, I didn't make any headway because the parties and their counsel were not cooperating in terms of where they held their mediation sessions. I mean, there was a particular case that I started. The first time the lawyer was in a bus, the party was in his apartment. It was a one-room apartment which he was sharing with a few people and some children. There was nowhere else he could go. And I said, I will not hold a mediation in these circumstances. There are people around. You have to go to a private place. It was during COVID. He couldn't go anywhere, So I adjourned the matter to another day. The next day, the lawyer was in transit in a car or something. So what I'm trying to say is that there are certain scenarios that you find yourself that you were just going to have to overlook for the sake of continuing the mediation. Now, if it's not intentional that the party or the counsel is trying to breach the confidentiality of the process by where he's holding the mediation, then you may just have to overlook such instances. And I also agree with Samir when it comes to where parties are now being blatant about the breach of the confidentiality. I think it's better you recuse yourself from the case, because obviously they're not coming in good faith. There's also an instance where a party can decide that if you have been injured by the breach of confidentiality, you might decide to sue. You might decide to sue the other party for breach of the confidentiality agreement, because right from the onset, and we mediators were also trained to emphasize and re-emphasize the confidentiality of the process. So anyone that goes to blatantly breach that agreement is actually doing it on purpose and does not and lacks a good faith. Now, it's also the duty of the mediator to remind parties that confidentiality, matters that are disclosed in mediation are without prejudice, because some parties and their counsel actually wait for information and data to be divulged in the mediation process and run away to use it against the other party. Any information that is divulged in a mediation process is without prejudice and cannot be used outside of the session. But I find in practice that sometimes when you have some banking matters and all that, the parties will tell you they need to get back to their superiors to hold a board meeting or to take some certain decisions, and everything that is discussed there is divulged. And there are all sorts of people in those meetings that are not a party to the mediation session. So the mediator must use the skills, to view the different scenarios and then take steps, necessary steps to ensure that they deal with such situations. Thank you.
Just
your thoughts also.
Doctor, if I
Okay,
can just
Samir.
here. You see, the issue of confidentiality can be more prevalent and more an issue in online dispute resolution, in online mediation, rather than in person. And
Exactly.
it is really very difficult to maintain that confidentially when you are doing it online.
Mm-hmm.
It is really very difficult. So that I think in an online mediation, the mediator is really put to a strict test of his or her skills to maintain that confidentiality and the whole process of mediation. So when we are talking of confidentiality now in the current scenario post pandemic, I think we have to be more careful when we are doing it online rather than in person, because to an extent in an in-person, in an offline mediation, you can still have a good control because the parties are in front of you, the counsels are in front of you, so you can still make out, from the body languages, and there are many other things to make out and control the whole process, but it's very difficult when it's online.
Exactly. Exactly.
Thank you, Mikro. Your thoughts on this?
Yes, Dr. Belusi, I agree with Samir and Mrs. Shunke so far. And I think what we could do, is with respect to the scenario mentioned by Mrs. Shunke, where you have parties that are not at the table. So institutional cases where a party is an organization, and ultimately the entire office hears about what happened in the mediation. I think our agreements, I'm not trying to recall if a confidentiality agreement has that, should then state that confidentiality agreement binds anyone from that company, your privies and your assigns, and that draft that goes. I'm beginning to think we should do that, because that can then cover, particularly where you have an organization. Because I was just listening to Mr. Shunke and wondering, institutionally wise, what we can do so that there's not an avenue to litigate. Because I know of a case, although it was online, where there was a settlement agreement between an employer and an employee, but his daughter then tweeted the settlement agreement, and it was confidential. And it was, till now I feel so pained. And the other party opted out of the agreement because the daughter had just breached the confidentiality. In fact, the man breached it. And this is the issue about confidentiality. He probably went home and gisted his wife and his children. And then, of course, the Generation Z went online. And then he lost out. So, yes, that's why I said I really do agree with the conversations that have been held. This is a difficult thing to maintain, and even more so online. Just like Mr. Shunke has said, just when we were trying to work on this online dispute resolution practice at the multi-door courthouse, we thought of so many scenarios. And we said we would tell the mediators to ask the parties to turn their cameras and show us the room. Show us the room. Let's see who is in the room with you. So yes, online it's tough. In person, I think we should stretch that agreement a little bit to bind others that might be involved in the process. And then if you call in an intervener more and more, we must create that space in the confidentiality agreement for the intervener to also sign. So thank you. Those are my thoughts in addition to what I've mentioned.
Thank you very much, Ms. Cole. I'm not going to leave you yet. I'm going to take this question from you. Like Samir mentioned, mediation deals more with the psychology of conflict than the legal rights. Indeed, when you come to mediation, you suspend your legal rights. As a mediator, you find that there will be issues of unfairness in the process. What will be the ethical obligation of a mediator who finds that possibly there's a power imbalance in the room, maybe a big business or bank versus a customer, or a represented party who has counsel, maybe learned folks with him, while the other party has no representation or poor representation, without getting into the fray or losing your impartiality. How do you maintain that power balance, and what should be your ethical consideration in such matters?
Okay, thank you. So we're discussing fairness and justice, and just one of the ethical codes that we have is that the mediator should not, at any point in time, provide legal advice. It's something we haven't put on the table. You're not meant to provide legal advice. The mediator, the mediation itself, it's not a legal process. Mediators can't give legal advice. Mediators can't decide who is right or wrong. Mediators can't force people to reach an agreement. So within the discussion of rights, the mediator cannot determine who is right or wrong or what legal rights exist between the parties. What we typically teach and what we practice is that the parties should come with counsel or get legal advice. But then there are those who do not have access to legal advice, who cannot pay counsel. What then do you do? What is this fairness and justice about? I give a story to let you know my thoughts around this. I handled a case a couple of years back, and then it had to do with someone who borrowed money to a friend to do some business. And along the way, the friend was ill, got ill, and couldn't pay back. And then during mediation, the man turned to me and said, "What is this all about, really? What is mediation about? What you people are doing here is something I could turn on you." In other words, he was saying, I would just go outside, loan money, and then come to mediation, and then say, I don't have the money anymore for whatever reason. So then what was in dispute was about $4,000. This really, really got me thinking. He said, I really desperately need my money now. And you're telling me that the man wasn't there. He sent a representative. You're telling me that this man is ill. And then he said, is this fair? Is what you're doing here fair? Are you telling me anyone can decide to do something and then run to mediation and use it as a shield? I've never heard that question before. Now, what is fairness and what is justice? Justice will speak to your legal rights ultimately, but fairness, of course, can speak to various things depending on your perspective on what fairness should be. And I think that in mediation, and not just I think that that's what it is, and that's what I feel it should be, in mediation, fairness and justice must be placed beside the needs of the parties. So that is the role of the mediator. The mediator is not there to give legal advice. The mediator is there to elicit and help the parties understand their own needs in all the discussions that go on. And by the time those needs are understood, the parties have a responsibility based on the self-determination principle. And that's why all these codes tie in. Based on the self-determination principles, the parties have the responsibility to determine what is fair and what is just. There is no real discussion in terms of legal rights, because if you stick to legal rights might not really be the solution to the needs of the individual. Take, for instance, a landlord and tenant matter that I once handled, where the landlord was of the view that the tenant should pack out. Yes, leave my premises, I've given the notices, just move. And the tenant said, I've taken care of your mother. You know, this is where Samir says mediation can get really quite psychological. I've taken care of your mother. You weren't here, you were out of the country. I bathed her, you weren't around. And now you want me to just move out. Shouldn't we have a conversation around this? I even built shops around your house. I've improved your property. I've done so many things. And instead, I'm not moving out. You pay me something. And we hear this all the time in landlord and tenant matters. What is then fair and what is then just? What will be just would be the legal rights of probably the landlord, because it's the landlord's house and he has a right, a legal right to that property, isn't it? But what is fair? Fairness, I would say, stops at the point of the parties' needs in mediation. In that particular case, the resolution of the case was now the need of both parties. What did the landlord really want? The landlord wanted to sell. If they didn't come to mediation, that would never have come out because there was ego on the table. The landlord wanted to sell, and the landlord said, this man, can he afford the cost of this property? the property was going for about 80 to 90 million. And then amazingly, the tenant said, I can pay. He was willing to pay between that 80 and 90 million. So now justice would be that the landlord should get his property, tenant should move out. But ultimately, it was the need of both parties that was paramount, and that was the basis of the settlement agreement that was reached. Now, so I'm thinking that's a way to look at this justice and fairness. It is not the responsibility of the mediator. It is down to the needs of the parties as to what would be fair, what would be just. And in terms of power imbalance that you referred to, if you do have in the room two people that obviously seem imbalanced, you could find out. I've had a case like that. It was an insurance dispute. It's one of my earliest cases. I've always wondered about that case. She had a lawyer, but despite the lawyer she had, I just felt there was, the insurance company was a bigger party in the room. But she had a lawyer, but her discussions were not as robust as I would have expected. You see, maybe I was biased, right? But I felt the discussions she was having were not as robust as she should have had, despite the fact that she had a lawyer. But what was my responsibility as far as I was concerned? I was following the code. The room was balanced out. There was a lawyer in the room. Now, if there was no lawyer in the room, then I could have asked, do you have counsel that could represent you? If you still don't have counsel that can represent you, the role of the mediator is to follow strictly the codes of ethics. If you follow the code of ethics, you will balance the room out. Because what you would be doing is ensuring that self-determination is enforced, there's no conflict of interest, or there's neutrality. So when you follow the code, you have balanced the room out, in my view, if that person cannot bring in anyone else into the room. So those are my thoughts. Thank you.
Thank you very much, Cole. I think the issue of self-determination in such scenarios, and I'm going to welcome now the president of the ICMC, Dr. Agada Elachi, here with us. Mr. President, you're welcome. I appreciate your dropping in here today, and we will be taking some concluding words from you shortly. Samir, following from what Mrs. Cole just said, issue of fairness and justice in mediation. One of the things we find the mediator should, as one of the terms of the engagement, allow parties to make an informed consent. So where a party has strong legal representation and the other party does not have, will he or she or that party be making an informed consent in signing an agreement?
Can you just
Doc, I don't think Samir heard your question. I didn't hear it either.
Okay. About informed consent, informed consent. We don't have legal. Yes, Samir? Can you hear me now?
Better, little better, yes.
Okay. I said, how do you ensure that parties have an informed consent, especially when they don't have legal representation, without giving legal advice?
Yeah, I agree what Mrs. Cole was talking about, the fairness and justice in the process of mediation, and to to try to work around the balance in the room so far as the parties and their legal representation is concerned. When we are talking of informed consent, I think it also goes to the root of the process as such, and it is definitely the duty of mediator to ensure that the parties have all the relevant facts and information which would help them to arrive at a solution or a resolution of the dispute. Though again it's little difficult because as Mrs. Cole said, and I agree, that you see, a mediator is not supposed to give any legal advice. However, I would just put her thoughts in a different way. You see, what happens is that as mediator, definitely he or she knows in back of his or her mind what is the law, what is right, what is wrong. Yeah, and it's a very basic, again, human tendency. At some point of time, we do make judgments about the facts, about the persons. Now, when you are, so this is, I am talking from a general perspective, okay? But when you are sitting as a mediator, although you know that this is what is law and this is what is right or this is what is wrong, it is your duty not to divulge or disclose this to the parties, but you can definitely, through the questioning, through your the way you are discussing with the party, especially in caucus, to send this message to the parties or to the councils that what they are doing is right or wrong. Yeah, without actually giving them an answer, without actually hinting them, without giving them any legal advice. And I think a mediator must do this. There are ways of doing it, not to be direct, but the way you discuss in the caucus, the way you question the parties will definitely, if the parties are legally represented, I am sure those councils would be good enough to take that message. A smart party would also be very intelligent to take up that hint, what you are sending the message about, whether they are going in a right direction or a wrong direction. And it does happen, and I don't think there is anything wrong in it, because ultimately it is your duty to facilitate a resolution to the dispute. Yeah, so there is nothing wrong if you are leading the parties to a correct path, which I think is one of your duty as a mediator. But at the same time, by doing this doesn't mean that you are giving them any advice. So it is up to the mediator, and that is why training becomes very important, your experience becomes very important, how you send this message to the parties or to respective councils, to which part to take, whether they are doing it right or wrong. And this is the way also where you can also make the informed consent part, I mean, share or divulge the facts and information to the parties without breaching the ethics. So I think that is very important from a mediator's perspective, to ensure throughout this process of mediation that the parties have that understanding, they have those facts and data with them to take this informed decision of whether to go further into mediation or even walk out from mediation. Yeah, so this is a very important aspect which a mediator must ensure throughout the process.
Thank you very much. Okay, so I'll just take one or two questions from the audience before we close. The first one I want to take is someone that asked a very nice, very funny question. He said, if the parties jointly, after signing the agreement, present a gift to you, should you accept it? Any of you can answer that. Together, jointly, out of their love and gratitude.
I I think if the parties are jointly coming, then there are less chance of breaching of the ethics for that matter, and many times there are I mean, you can take fees in kind as well. There's nothing wrong in it, but not unilaterally. If they are jointly coming, then obviously I think then there cannot be any question of any of the parties later on making any allegation on you, because they have come jointly. However, the best advice I would still say is to avoid. You see, you never know what goes on behind the
Obviously.
back of those parties, because they might be hand in gloves together, and making you as a scapegoat, as a mediator. So I don't advise, in spite of whatever maybe you have that influence in your mind, how much greedy you are being, how much you are tempted. I think you still have to be very clear not to accept it.
I agree with you, Samir. I agree.
You all agree?
I
was
agree.
listening.
I agree entirely.
I was
No
waiting
matter
for
how
Samir to land.
even if it's a house in Banana Island. I agree with
Okay.
Samir entirely.
Yeah.
The second one I think goes to Yejide. Someone says, can a mediator be sued for breach of confidentiality? And does the mediator have immunity?
Well, can the mediator be sued for breach of confidentiality? Is that the question?
Yes. Have immunity.
Well, from what I have learned, a mediator cannot be sued for whatever takes place in the mediation process. You cannot use what she has said against him or her. It all boils down to the issue of confidentiality of the process. You can't take what has been said in the mediation and then go and use it against the mediator. I don't know if Mrs. Cole can throw more light on this, if I'm correct.
Yeah, the first part, really, we cannot be sued as mediators, and the agreement says we cannot be sued. The second part, I would think that if you do breach confidentiality, you can be sued, because in that instance, you're not protected anymore. It's part of what you signed that you would not breach confidentiality. Samir, over to you. But I think
I have a question though, because I had mentioned some difficult scenarios earlier on that I've heard about, where what is breached is a matter of life and death. For instance,
that's different.
Are there some exceptions to?
There are. But the thing about the exceptions, for instance, just like you said, things of a criminal nature, definitely threat to life. Under those circumstances, you probably can escape some form of legal suit. But however, in Nigeria, there is no law governing the exceptions. I know in some states in America, it's very clear in those states. It's stated in their rules or their laws what these exceptions are. So I've always wondered in our crime, since we don't have the exceptions documented anywhere, if you do breach confidentiality without any document saying you can't breach confidentiality, what then would be the outcome in terms of a legal suit against the mediator? So that hasn't been tested yet. I think it can be. I think it's possible that if you breach right now, it will be left to the courts to take the decision. That's my view.
I want to believe that a mediator breaches a confidentiality in the sense that, for instance, somebody has been molesting his child and he divulges such an information to you. I don't see how that party will even sue you for that kind, because at the end of the day, it's a criminal offense, and though it is not documented, I want to believe that that exception is so strong that even a court of law
would uphold it.
Because the court of law is supposed to uphold justice. You cannot molest a child, abuse a child, rape a child, and the mediator discloses such, discloses such a confidential information, and you are now punished for it.
So I agree. And I'm saying, yes, the court eventually, that's why I said the courts will test it. So the court obviously would uphold that kind of situation based on the exceptions. And then even if you stretch it further, for instance, we had a case where the man had HIV and he says, don't disclose to my wife, but you know that the wife can get it, the children can get it. Should the mediator disclose? So the conversations can continue along that path. What are those exceptions to confidentiality, and can the mediator be sued? So I agree with you. Ultimately, the courts would uphold the need to breach the confidentiality under certain circumstances. Maybe if we put them under things like threat to life, public policy issues that are huge and affect. For instance, somebody says, I want to throw a bomb in the market, and are you going to keep quiet? So those extraneous, circumstances, criminal in nature, and all of that. But I'm just saying, it hasn't been tested by the courts, but hopefully the court should uphold it.
But who does the mediator disclose to?
Yeah, this has always come up. In institutional mediation, we say, take it straight to the institution. The institution should be able to report to the relevant authority. So for that's institutional mediation. But ad hoc mediation, I've always wondered, you probably go to the police because you need to do something about it, or whatever channel is available. So for instance, if it's a criminal charge, the police; if it's molestation, you go to the relevant authorities in Lagos, like that, or whatever jurisdiction you are around the world. Those are my thoughts.
Apart from the criminal issue, this can also happen in commercial mediations. Let's say a party discloses to the mediator that, yes, I have laundered money. Yeah, I have played fraud on the bank. Now what does a mediator do? And the party is disclosing this in a caucus. Yes, the party say, yes, I have laundered, I agree I have laundered, but now I want protection. You don't disclose it. So this can happen in even a commercial mediation. It can happen in family disputes. So what I think is the test is, when we are talking of confidentiality, I think it has a limitation to the extent that if you have to test your legal rights, your fundamental duty towards the society in general.
Yeah.
When that is questioned, I think there is no question of confidentiality breach. You must follow what are your fundamental duties as a citizen to the society. So then I don't think any court will question your breach of confidentiality if you are performing your fundamental duty, your constitutional rights.
Yeah. Thank you, Samir. At the ICMC, we say, thank you, Dr. Lubringa Barada, for reminding us where criminality starts, confidentiality stops. So where criminality starts, confidentiality stops. So I think that's a good takeaway for us. So I want to thank all of you for your time today, and I'm just going to go around the room to take 1 minute closing remark from everybody, and then I will invite the president of the ICMC to give us the final closing remarks. I thank Dr. Obiefu, Louis Brown Obiefu, Bidon, also here. Recognize you. Thank you very much, sir. So I'll just go around the room. Yejide, Samir, Disco, your final words, and then I'll invite Dr. Elachi to round up for us.
Well, for me, I'd just like to say that, as Mrs. Cole has said, once we follow strictly the codes of conduct of the different institutions that we are affiliated with, I think we should be home and dry. We should be fine. I think also that webinars like this, because so many questions have come up in the chat and in the Q&A, that suggests to me that a lot of us mediators are still confused about a lot of things. Yes. And for me, I've been a mediator for many years, but I'm still confused about a lot of things. So I say kudos to the ICMC for putting up this webinar. I think that these types of webinar with different topics should come up very often, so that we can train and retrain ourselves, refresh our memories, learn from each other on what to do in certain scenarios, certain instances that we find ourselves. I mean, even if you are an SAN in mediation, you can always learn one or two things. I have learned a lot from this webinar today, and I've been faced with some scenarios which haven't listened to Mrs. Cole and Samira today. I know where to take matters to when next I'm faced with such scenarios. So thanks very much, the ICMC, for inviting me, and to Mrs. Cole and Samir for your discussions. Thank you.
Ms. Samir, Ms. Cole?
Oh yeah. I think I would conclude by saying that in court of law, a party gets law, but when you come to mediation, you really get justice. And why so? Because ultimately, a heavy duty, a big responsibility is cast upon the person whom we call a mediator, who is the guiding force for the parties to channel them into a win-win situation. So in doing this, I think a person as a mediator needs a space, a freedom, a flexibility to do this. So if we are talking of ethics, codes, processes, procedures, rules, then I think we are limiting the whole process. We are creating a boundary which is not required. However, at the same time, if we just leave it open, then it will become a fish market. So I think what is required is a very, very critical balance between what to do and what not to do. But this should be left to the person as mediator, to different cases, different circumstances, the parties themselves. Let they decide what is good for them. As Mrs. Cole just clearly pointed out, it is for the parties to decide the fairness and the justice what they need. So let that decision remain with the parties, rather than we are codifying it as a process, of what is good and what is bad. In one case, something is good, but the same thing can be looked as as an unethical way in another case. So we cannot lay down an exhaustive standard, but yes, what we have today are good enough to proceed further. That's what I would say. Thank you. And yes, definitely, it was an interesting discussion we had today. There's a lot to be discussed. It's a very, very vast, wide topic. Time is so short to share our experiences over a period of time. So I would request doctor to please do these kind of webinars frequently, so that we can share it in a more detailed manner and for the benefit of all. So thank you, Mrs. Osunke, and thank you, Ms. Cole, for having a great discussion today. Thank you so much.
Thank you.
Thank you,
Thank you,
Samir.
Dr. Wilisi. I'd say, just like Samir has said, particularly from the institutional perspective, we don't want a fish market out there. We want a situation where there are guidelines, so that's the essence of the codes. But it was amazing listening to Samir and to Mrs. Osunkeye today, and pushing the boundaries of ethics and the conversations around it. For us in the institutional sector, it's so important for us to know the thoughts out there and how we can modify what we do. So I would also say this was very rich, very engaging for me, and I think we should continue these discussions. They can only help build the practice and promote the practice. So thank you, Samir. Thank you, Mrs. Osunkeye. Thank you, Dr. Bilisi, and thank you, ICMC, for inviting me. Thank you very much.
Thank you very much, Ms. Cole. And I call on Dr. Agadai Lachi to give us the final words before we close.
Dr. Agbelus, thank you. Distinguished panelists and our participants, let me, on behalf of the Institute, congratulate Lagos branch of the Institute for this very, very laudable initiative. I have enjoyed listening to the discussion, and I say the panelists have been wonderful and have discussed the issues and given depth to it. I agree with Samir that we should make this kind of discussion more regular, And indeed, if it is possible, there should be a part 2 of this particular seminar talking about the issue of ethics. Ethics go a long way to guide the conduct of any proceedings. One very interesting thing I've learned in my experience as a mediator is that when parties come to the process, sometimes, and indeed counsel representing them in many cases, they don't even understand the difference between mediation and arbitration. What would be tragic is where the mediator also does not have a good appreciation of what the boundaries of their role should be and how to undertake that. One major thing that I hear from fellow mediators sometimes is the pressure to attempt to get the parties to reach a resolution. And while mediators are facilitators and essentially our job is, yes, to assist the parties reach a settlement, the task of reaching a settlement belongs essentially to the parties. And the mediator must refrain from trying to compel, even if indirectly, parties to get to a settlement at all costs. So I think this is great. It's been wonderful. You've done very well. And I think I looked in the room, we have 58. At some point, I think we had nearly 60 participants. This is very impressive. We need to do more of this. So Dr. Agbelusi and your team, congratulations. I look forward to a part 2 of this. And of course, I will be in attendance, and as well as when you set up other webinars for many other interesting topics. And I hope that other branches of the Institute eat from this example that you have. Thank you very much. Thank you, our panelists. Wonderful.
Thank you, Mr. President. Thank you, our panelists. Thank you, all our attendees, all our eminent excellencies who are here today. Indeed, the part 2 is we are preparing the part 2, which will come shortly. We're going to be exploring exploration in mediation, looking at questions, probing, and how far should you go to get the parties to settlement. So that panel is being put together, and I'm sure you soon see the flyers, so we will definitely make it a sort of follow on to this, exploration in mediation. And I'm sure that will be another interesting topic. So the ICMC Lagos is putting that panel together. So thank all of you all for coming here today, and I wish you a wonderful, wonderful evening and rest of the day wherever you are. Stay safe and stay strong. Thank you.
Thank you.
Thank you, everyone. Bye.